Okay, well, welcome everyone out there to another Sunday afternoon class from the Brigham Young University Family History Library. We're grateful to be able to be here, and we're thankful for the technology that lets us broadcast these classes. We are going to talk about probate records, and kind of as a brief introduction, probate is a fairly complex legal process. In fact, a lot of people have spent a great deal of time and money trying to avoid probate, but as genealogists, we do not want to avoid probate. We want to make sure everybody had a probate because we get lots of records from their probate. Anyway, so there's kind of competing interests here. But what probably is the difficulty is you have, the regular jargon or specialized language that is used by genealogists, and then we top it over with a very specialized language used by attorneys. So this is an area. But one thing I would like to very much emphasize at the beginning, and I hopefully as I give the class, is that it's worth it. It's very much worth it because probate records are a valuable addition to the standard census, vital records kinds of things that we look at all the time. Once you do find a good probate record that has a will and all of the other parts of it, and you begin to see how the whole family sort of unfolds in the probate, then that really answers a lot of questions. And in many of the end of line situations and what you might call brick walls, looking for a probate record is the key to kind of getting through some of those particular problems. So let's go right into it here. What is a probate? Okay, a probate is a set of court or government procedures established for the orderly transfer of property from a deceased person to his or her heirs or assigns. I'm going to have to kind of define things as we go through this because there'll be definitions that'll need definitions. The heirs are the people who inherit the money, either because the person has a will and names the heirs, or because the place where the probate occurs, usually, and we're going to talk primarily about the United States, has some sort of law that says who gets the property if there is no will. And the assigns are people who are given money in the probate for a particular purpose. For example, pay bills, or to give certain sum of money for a scholarship or something like that. In other words, an assign is different than an heir. An heir has a legal right to it, and an assign would not receive but for the assignment made in the will. Okay, so that kind of clears up those terms a little bit, hopefully. If you have questions, obviously put them in the chat or in the Q&A, and we'll answer all the questions at the end of the presentation. So probate can be with or without a will. So let me kind of set the stage here. So we're going to talk about a person named John Doe, which is the standard person that, or Jane Doe, the standard person that we use in law discussions. So John Doe lives out his life, and he owns some property, and he has some money stashed away, and he has a family, and he has some children. And so he dies without a will. He doesn't make a will. Well, then there's kind of a common conception in the United States that is totally erroneous, that all of his money would then go to the state, that without a will, nobody in the family would benefit. Well, that may have been the case at some point in the history of some of the parts of the United States and or England, but it is not the case today. Today, any place in the United States where a person dies, there is a will written for that person if they have none. And so that will is a statutory outline of the way that the money is going to be distributed to the surviving spouse, to surviving children, to the surviving parents, to the surviving siblings, to the surviving brothers and sisters of the parents, to the, so forth. So it can go down, usually about 4 levels is the common way that it goes in the United States. Going back in time, however, you need to look at what the probate laws were at the time that the death occurred, because the laws do change. And going back in time requires a little bit of knowledge about how that money should or could have been distributed had there been a will or there was no will. Well, then we get to the two terms here. Testate means you die with a will. Intestate means without a will. So basically, if the person, John Doe, had a little bit of foresight in this case and written a will, then he would have that document would have been the basis for the action rather than the state law. So it was substituted in. That may or may not have made the beneficiaries of the will, those who are going to receive the will, that inherit the estates, the heirs, and assigns, they may or may not have been happy. And obviously, if you've watched any kind of television movies or series about law or detectives or the police or whatever, you'll learn that this is usually a kind of a dramatic time, and can be made more dramatic by having a fictitious plot. Okay, so testate is a word we use all the time, meaning with a will. Intestate is without a will. So now let's see. So what we're really interested in as genealogists is not who got the money, but that they were named in the will, and hopefully that the person who drafted the will, the deceased, made an attempt to tell how he or she was related to each of those individuals. There's also kind of another, I guess, myth out there that exists in historically, is that men made all the wills. Now that's just not true. And basically, you can find the wills for the wives going back clear to the earliest years in the colonies in the United States. So it's just not, some of these things that you might hear are just simply not true. So it's the records that are kept during the process of the probate that are important. It's not necessarily and it helps us because it usually identifies the members of the family, sometimes with their spouses, and sometimes even specifically about where they live or where they're living at the time that the will was written. But we just hope that the individual who makes the will gets really verbose and says a lot of stuff about his family or her family, because that will give them an opportunity to move on, and will help give us an opportunity to move on with a lot of information. One of the most important things about probate records is that they're essential because they often predate birth and death records kept by civil authorities. If we look at the United States and any other country, but we focus here on the United States only began, the states within the United States, individual states, only began keeping track of birth, death, and marriage records relatively recently. The vital records, particularly birth and death records, were not uniformly enforced and kept in the United States until well into the 1900s. In fact, there are some states that were not uniformly recording births and deaths until even as late as 1960. So you're relying on vital records or looking for a birth record or a death record sometimes is not it's not going to happen. We're not going to find those records. Marriage records, by the way, are much more valuable and much easier to find, because a marriage influences the ownership of property. It affects the rights that individuals have to property. And so marriage records have been kept since antiquity. There's always a marriage record somewhere, whether unless people failed to get married at all. And even then, there could be records that indicate that there was a cohabitation situation without a marriage. So this is something that is kind of on the next checklist. Obviously, if you find some information or a lot of information about your family members, you would perhaps do by looking at vital records and census records and other kinds of records. You may not have a lot of incentive to look further into probate records. Another problem, of course, is that there are lots of other kinds of records that are digitized, but probate records are usually not. There are far fewer probate records digitized and available in the large online databases and in other places, and particularly not in courts. It's not often that the court will have digitized especially older courts records, digitized probate records. But there are millions and millions and millions of these records out there. It's not saying that there's not possibility, but it's just that they're a little bit more difficult to find, and they're a little bit more difficult to read through and work with. Okay, so here's kind of an outline of the value of the probate files for research. First of all, and most importantly, it helps to identify family members, the actual family members. Let's suppose that you're doing some research and you get on to familysearch.org, or you go on to Ancestry, and all of a sudden this family that's on there that you're looking at has three more children than you have ever seen or heard about. And you go, well, I don't know if these children are there or not. And you look for other records, and you finally just get really kind of at wit's end, because you can't determine whether or not these people are part of the family or if there's missing members of the family. Well, if you are fortunate enough to realize that you can look for a probate record, and that you once again are fortunate enough to find one, you may very well clear up all of those issues in one set of documents, because the probate records may very quickly name all the individuals, all of the children, and show their, in a lot of cases, as I mentioned, their spouses. And it very much clears up the whole picture. And one of the other important parts about this is it may give the wife's maiden name. Now, even if it doesn't say my wife with her maiden name, it may have witnesses attached to the probate, and particularly to the will or to the probate action itself, whose surnames are different from the person who made the will or is involved in the probate, the deceased. And so those names may very well be the names of the wife's brothers and sisters, family members who participate in the proceeding, because they are taking care of the wife who has survived the estate. And if it's the wife that dies, then you can almost be assured in a lot of cases that someone that shows up in the probate is probably the wife's a relative from the wife, and may have the wife's maiden name. So there's a lot of ways that a probate can help that. The third thing is to establish the relative economic status of the family. Why is this important? Well, it's easier. It may seem unfair, but it is a lot easier to do genealogy for rich people than it is for poor people. Poor people have a tendency to disappear. Rich people have a tendency to have a lot of property and probates and all of this kind of stuff that lets us find them easier. more easily than we could if we were looking for someone who dies without anything. So this is the kind of thing that helps you. And it's also interesting to look at the relative economics. One of the things that my wife and I did a couple of years ago was to spend a mission for the Church of Jesus Christ of Latter-day Saints in Annapolis, Maryland, at the Maryland State Archives. And we digitized probate records for the whole time we were there. That's all we did was digitize probate records. And it was, and all the stuff that goes with probates and the death records and whatever. And that was just, it was just amazing, because you would find probates were probably, given today's dollars, the probate estate was in some cases less than $100. And in other cases, it was probably into the millions of dollars. And so there was just, the disparity was just incredible. And we were always saying, oh, look, this poor person died and all he had was 4 pins. You know, they didn't have anything. Oh, and this brings up another very important subject. And that is, as you go back in time, probates are much more prevalent than they are today. It's very, very common today. We have a way in the United States to avoid probate, as I mentioned briefly. And that is to transfer property into what we call a trust. That makes it more difficult for a genealogist to find the family or find any information, because those trusts aren't recorded or filed with any court. So it's just simply not, from us, it's, as a genealogist, it's not a very beneficial trend in the United States. But fortunately, because you go back in history, particularly back into the early 1900s and beyond, you'll find out that in some cases, virtually 100% of everybody had to go through probate, even if they didn't really own very much at all. And so it's more and more prevalent. And this may also be the only record of the ancestor's death. I mentioned about the fact that states in the United States did not begin recording that information as early as we would have liked, but they did, and they have had probate since the very earliest colonists arrived in the United States, in America. And so that really is these are really a body of very, very important records that we maintain. So what are the things you might find in a probate file? And this is a actual copy of one of the documents that we digitized back at the Maryland State Archives. And if you look at the bottom of the image there, you'll see a little drawing that looks like a pretty interesting thing that would have been done by somebody, and that usually not of the age of the people who were involved in this. But this was interesting because you had to, in those days, you had to have a seal, a court seal on the transaction. And these were copies of the original records in these books. They copied them into these books to preserve the records. And the people who were copying the records decided to add their own versions of the seals. So these were kind of interesting things that happened. Okay, so what are we going to see when we open up a probate file? First of all, a probate file isn't a document like a birth certificate or a death certificate. It isn't something that you see, oh, there's the probate. It's one document. A probate file may contain hundreds, I would say up to thousands of documents in one file. And so that's another reason that makes them extremely valuable, because there's just all this information. It's just exhaustive information. Another important thing is that births and deaths usually talk about one event, whereas probates can drag on for years and years and years in the court, and basically be there for more than the lifetime of the beneficiaries of the estate. And so it's you not only begin to see the names of all the people that were associated with the deceased, but you begin to see their children, and you see more than one or two, even two generations of people that are involved in these extensively long probate cases. So first of all, you're going to see a will. A will is a document that a person makes when they are anticipating their demise, their death, and they make this document to instruct the person who is going to administer the will, originally called an executor or an executrix, and the executor of the will or the administrator of the estate. Okay, so you've got more words here. Executors worked with wills, administrators that worked with estates without a will. And so there's you start to see changes in the words. So good idea, and I'll come into that in a moment, is to have a good legal dictionary available, and be sure to check out the meaning, and that you understand the meanings of all the words that you run across in any court document, or any document for that matter that you're dealing with as a genealogist. You should have a good, at least memorized how to get the definition of words from Google almost immediately, which is by putting the word in your search, define, and then put the word, and it will automatically give you the meaning of whatever you type after the word define. And so that's one way, but another good way is to have a good online dictionary and look up words, specialized words. Bonds are money that were paid to assure some kind of an action on the part of someone. So let's suppose that there was a will and it named someone as the executor of the will, or the executrix, person, male and female versions of the word. And by the way, all of those gender specific words have disappeared from our legal system by now. Today, anyone, whether they're male or female, is called an administrator, and there is no more executor, executrix stuff, except there may still be some states that have that. Basically, the bonds were there to ensure that the executor did what they were supposed to do and distributed the property the way it was supposed to be distributed. And so there's another document there that says that this is how much this executor person had to put up with the court as a insurance policy, or assuring that the property would be handled properly. Petitions were asking the court to do something. In other words, you write out a thing that says, "Dear court, do this." A little bit more complicated wording, however, but and there's some formal provisions that you have to have in a petition, but they're basically requests for the court to do something, allow somebody to act, distribute some money, pay a bill, sell a piece of property. All of these things are done by petitions. So almost everything that was done in the estate is going to have some kind of a petition. It may have somebody responding to that petition and being either in favor of it or against it. And then there may be a decision by the court that's called a ruling of the court that rules on the action. And if there's a ruling, then there's usually an order issued by the court enforcing whatever the petition requested, or denying the request of the petition. Okay, if what I'm talking about sounds like gibberish and it's way above your head, then the idea here is that I will go through and give you kind of an overview. In other words, what we're going to look at here is, this is how it happens, and these are all the terms that you need to know. But you can come back and go through this, and this will be online at the BYU Family History Library YouTube channel and on the BYU Family History Library website. So this is going to be an ongoing kind of reference point that you can come to and learn about. But on the other hand, it's also important to go and learn a little bit more about it. And there's just an overwhelming amount of information online about probate and probate procedures and things like that. And then if you really get in trouble, you can always come and ask us, somebody who has been through this process a number of times. And then we will be able to help you. Inventories, okay, usually, almost always, the court will order that there be an inventory of the estate. There was two reasons for this. One is to ascertain what property actually was owned by the deceased when the deceased died. And the second part of that was to figure out whether the state or whatever was going to charge taxes on that. And there are a couple of different taxes out there. And the fact that all of this process ended up with some kind of revenue to the state almost assures that these processes were done pretty consistently. Now, an order follows a petition. So I already mentioned what the orders were, but those are things that come from the court, meaning the judge, the probate judge, who makes these petitions. And then there are decrees. A decree is at the end. The decree decrees that the will has been probated, meaning it's been admitted to the court and examined by the court, and it is held to be a valid will. And then they decree distributing the property in accordance with the will document, or distributing the property in accordance with the law of the state. So in that decree is usually the good news for the people involved in the probate action, because it can be a long period of time, and that means it's all over, folks. And except for the last step, which is that the administrator had to do deeds of distribution. Now, this means that there's division between two kinds of property. You have property that have titles, that's called like real estate and cars and airplanes and things like that. And then you have property that is untitled, which is usually called personal property. And so the personal property could just simply be handed over, but anything that required a deed needs to be signed and delivered by the court, usually signed by the executor or executrix of the estate, or the administratrix of the estate. Okay, how long do you think it took me to learn how to say those words? Quite a while, believe me. They're not easy to say fast. Okay, so now let's see what's going on. Okay, so how do I know there's a probate? How do I just guess? The answer is, yeah, pretty much. But there is a way to find out fairly quickly whether there is a probate. And that is to figure out if the person who died owned a piece of property, real estate, a farm, a house, something. If they owned real estate back a few years, starting back in the early 1900s, it is extremely likely that there was a probate, because the only way to transfer that property from the deceased to his or her heirs was through a deed of distribution from the estate. And so the property had to be probated. So what happens? So for example, let me give an example of something that might happen. So back to John Doe, or Jane Doe in this case, we'll call it Jane Doe this time. Jane dies, doesn't have a will, doesn't seem to have any property. Nobody worries about it. There's never anything that has to do with probate or anything. Years later, 20 years later, let's say 30 years later, all of a sudden somebody decides to sell a piece of property that they've been living on for the last umpteen hundred years. And what they find out is that Jane's name's on the property. She was a part owner or the owner of the property, and they just didn't know it or had forgotten that. And so all of a sudden they say, well, we want to sell this property. And they say, well, too bad, going to have a probate. So probates don't necessarily have to coincide in time with the decease of the person. The person's death does not necessarily, it can trigger a probate action, but the time between the death and the probate may be months or years. And so probate actions can be valuable because they not only happen at the time of the death, but they can happen in series over a long period of time, as I've mentioned, or they can even begin many months, years after a person has passed away. Once all of a sudden they find out there's nobody left who can legally sign this deed because the people died or the person died. Okay, let's move on. What are some of the basic limitations? What's the basic limitation of a probate action? Well, the basic limitation is something I've alluded to and spoke about briefly. No property, no probate. So if your people are really, really poor, they're just dirt poor, or they don't own anything in particular, then it's very, very unlikely that they've been into court. Now, let's kind of go back a little bit further in time before into the early part of before there was the United States of America, when there were colonies, and when most of this law, which came from England, is called the common law, and probate. All of the probate all of our probate laws came originally from England. In later years, in the last 50 or 100 years in the United States, most of the early laws as they were written have been rewritten and amended and changed and updated. So it's very unlikely that the way that your state's law or your part of the country's law handles a probate was anything like it was back in the days of the early days. The important thing and the good thing about it for the genealogists and historians are that a lot of the terminology has not changed, and a lot of the forms have not changed, and the basic concepts have not changed. But notwithstanding the fact that probates reached down into people who had very little property, if there was no property, it was entirely possible that the person avoided, that the heirs were able to avoid any probate action. And that's basically the way it is today. Most people think they have to file a probate action because they have to pay estate taxes in the United States. Well, the current threshold level for paying estate taxes in the United States is many millions of dollars in value. You have to have over millions of dollars of property before you pay any estate taxes. So if somebody is telling you that you need an estate planning device because you're going to end up paying all your property is going to go to estate taxes, then that's simply not the case. The first question you say is, okay, what's the current exemption for estates? Now that could change tomorrow with the United States legislature, so don't count on it. You should always know what that number is and be aware of if that makes it important for you to go out and get an estate done. What is an estate? Now, I've said that word maybe 50 times. The estate is everything owned by the deceased at the time of death. Everything is in the estate, everything. So how do we know whether somebody owns that thing or that thing? Well, that's where some of the controversy comes out in the probate actions, is determining whether or not the deceased actually owned this piece of property or actually owned that thing. The silver set or the fine china or the paintings or whatever. And it's very often that becomes part of the issues. And also that makes it a lot more information for genealogists, because then you bring in a lot more people who are relatives to give testimony and to provide affidavits and to make claims. So that's kind of the, it's kind of a good news, bad news. Bad news for the people who are related. Good news for all the genealogists. If the law does not recognize individual property rights, then obviously they cannot pass their property on to an heir, and therefore, if they don't own it, they can't pass it on, and so there is no probate. So this kind of really limits it. Why is this a concern in the United States? Well, we have people in the United States who legally could not own property. Not going to go into that with too much detail, but in England, there were lots of people who could not or did not own property. So that's kind of a very common thing, and you need to understand individual property rights historically, so you can tell whether or not your ancestors were in the category of those people who may or may not. Now, my ancestors, for example, for most of them that I have found in the many, many years that I've been working and doing genealogical research, I have yet to find anybody who was could even be considered to be in the position of being wealthy. In fact, many of my ancestors were tenant farmers, or even into the poorhouses. So it's not, maybe you have a different set of ancestors, but my experience, my personal experience, has not been that probates have been very helpful to me. But it could always happen that I find somebody, and from time to time, I really solve some really sticky questions by finding a probate file, even with my ancestors. The other part of that is that individuals must have the right to alienate or transfer property to spouses or others on death. Not every place in the world recognizes the right of people to transfer their property on death. So that's another reason why there may not be any probate. Okay, here's some more terminology. I'll just kind of review some, and I will make sure that you have heard these more than one time. Testator or testatrix, that's the person making a will. So the person who makes the will is called the testator. And there's some other terms that apply also. Administrator, person's administrating the estate without a will. I said that. The female version is administratrix. Okay, so you'll see that. Executor, executrix, person who administrates an estate when there is a will. And a personal representative, anyone administering an estate. This is part of what's called the Uniform Probate Code. Just as I started law school back in 1972, the Uniform Probate Code was starting to be adopted by certain states within the United States, and Arizona, where I went to law school, was one of the first. And so we studied the Uniform Probate Code, and I never had to study the old Probate Code because Arizona was one of the few. Now it was anticipated that all of the states would eventually accept the Uniform Probate Code. That has never happened. And so you have Uniform Probate Code, UPC states, and non-probate code states. But then there are some states that have adopted parts of the Uniform Probate Code. So anyway, it's as usual, and law is very complicated. Who are the heirs? Those persons entitled to inherit the deceased's property. So this is a person who, regardless if they know they're an heir or not, they are still entitled to inherit the deceased property in some case, depending on the existence of a will or not a will. The fact that a person is not named in a will does not mean they're not an heir. The heirs do not automatically receive money out of or property out of an estate. They only receive that if they happen to have if they're included in the will, or if they are also included in the category of heirs that are allowed to receive property through state statutes. So this is the point. Who they are is established by the law of the place where the death occurs. So think about that. It's not where you live, it's where the deceased person lives that determines whether you are an heir. Or it could be established by the law of the place where the property is located. Okay. And yes, you might have multiple probate actions. And in many cases over the years that I dealt with, there was property in more than one state. In one case, I think there was at least 7 different states. I think there was one with 12 different states. That number sticks in my mind. And in order to probate, we had to do what was called an ancillary probate, separate probate action in each of those other states. So the estate ended up hiring an attorney in each state to do that little action to get that one piece of property in that state distributed. So now if you're thinking in terms of this in law, that sounds like a nightmare. If you're thinking in terms of a genealogical research issue, all of a sudden, this is the best thing that ever happened, because here's all of a sudden people all over the country that are being identified. Established by the place where the deceased resided at the time of death. Okay, so it could be where the death occurred. It could be where the property was located at the time of the death, or it could be the place where the deceased was residing at the time of death. And it might not be where the person died or where the property was located, or what is established by a will or other testamentary document. In other words, all of this and the will may determine exactly where the probate takes place. They want the probate filed in, and they name the place where it's supposed to be filed. Okay, now go back to the issue of where do I learn all this language? How do I pick up these words? This huge amount of terms, which, by the way, is just barely scraping the very edge of the words. The words get, one of the most common things, and one of the things that happened, of course, one thing that is important to understand when you're listening to me is that I spent 39 years of my life involved in litigation and law, involved in going to court. And I basically say I was a trial attorney because that was the main thing that I did, was to go to court. And since I spent all those years in court, the language, of course, was just what you said in court. But I very often would have clients who would insist on coming with me to the hearings, particularly probate hearings. And then we would go through the probate hearing. And when we got through, the first thing that the client would do would run up to me from where they were up to where I was and say, "What did they say? What went on? What happened? What did the court decide?" So don't feel bad. This is really kind of where it is as far as law is concerned. This is the book. If there is one book that helps genealogists through this process, it is this one book. It's called Black's Law Dictionary. And it doesn't have to be the latest version. The latest version isn't going to help you any better than some of the oldest versions, 100-year-old version of Black's Law Dictionary. In fact, the old versions may have some terms that have fallen out of use. But Black's Law Dictionary has been digitized. It's online. It's in databases for free. There's no charge. If you want to get a copy, a paper copy of the book, it's fine. You can probably buy one pretty cheap. You don't want to buy the latest copy because it could cost upwards of more than maybe $100 or more. But you might want to buy an older version of the Black's Law Dictionary just to have it laying around. This was the one book that was on my desk, or my credenza, the desk behind my desk, during the entire time I practiced law. This was the one absolute, always was there. every attorney that I knew had a copy of this and had to look up these words. It was not unusual to have to look up words. Even after 39 years of being in law, I still had to look up words. So don't feel bad. Once again, it's available for free online. Just look for Black's Law Dictionary. Just don't pay money for anything. Just go up there and find the Black's Law Dictionary free version and use that. Okay, now we haven't even answered this one. So what's a will? A will is a document created by a person before death that attempts to influence the distribution of that person's property after death. Let's emphasize the word attempts. Many people think that, oh, the will, he's got to, we can't violate the will. The will is what happens. Oh, well, we wish. In truth, almost all the problems that happen with probates happen because people disagree over the provisions of the will. And they think they're unfair, or they were influenced by duress, or they were because the person wasn't in the right mind, or they would never have given all that money to their cat because I really deserved all the money. So this is the kind of things that basically create more litigation, more discussion, and more advantages for the genealogist. That we get a lot more records and a lot more information out of everything. Important thing about wills is there are legal restrictions about how a will is made and whether it is a legally enforceable document. And that has changed over time. And that's one of the things that you need to know about whether the will is valid or not. And it must be in writing or witnessed, or it must be in the handwriting of the deceased, called a holographic will, or it may be oral if witnessed and written down at the time or shortly thereafter. Okay, so these are called different types of wills, and that gets a little bit complicated too. But that's another thing to understand is that an oral will can be valid and can be enforced, and a written will can be valid and can be enforced. So a handwritten will. And it doesn't help that probate law has always been complicated. The answer is yes, it is very complicated, and it has always been complicated going back to antiquity. So it's just something that you have to do. But once again, it's like, like they say sometimes in sports, no pain, no gain. In this particular area of the law and of this particular area of the of genealogical research, there is a great benefit by getting the information and gaining the information necessary to read through these documents. You do not have to get a law degree to read the documents. It might help, but there's too much other stuff involved in getting a law degree that doesn't have anything to do with probate documents. So it's probably not worth it. I did have a couple of the people I knew over the years that got so frustrated with the law that they actually signed up and went to law school. But that's kind of an extreme reaction. So understanding that the earliest laws in the United States came both from England and from Spain. And so we have what's called the English law, the English common law, and we have Spanish law and or civil law. And the civil law is quite different. And so some states actually have parts of the law that are very much different than they are from the rest of the country. We have what are called common law states, and then we have what are called other states that derive from the Spanish law. And that's something you need to know. Both English common law and Spanish civil law are used in the United States depending on the state. So you may see both. There are 9 civil law. These are called community property states. Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin, and sometimes Alaska. not all of these states have really strict community property laws. Some of them borrow parts of the community property law. Usually the ones that are the North, Washington and Wisconsin and Alaska. But you can be sure that Arizona, California, and Nevada, New Mexico, Texas, and Louisiana have laws that are substantially different than the rest of the United States when it comes to property and probate. So probate files. So here's a copy of a bunch of files. Probate actions generate a series of documents filed with the court. Those are what they are that are called probate files. The file is the whole set of documents. All the documents or pleadings filed with the court are preserved by the courts. And to the extent possible, barring fires and other disasters, probate records are preserved. And as we saw in Maryland, we began the process of, or had begun, we stepped into the process of digitizing a lot of the probate records. Do not expect that anything other than the name of the deceased will be indexed at any particular time. These documents are very complex and very long and spread out over different time periods. And so they're very difficult to gather into one file, depending on how the court preserves them. Just finding the documents is a challenge. How do we do that? Search online. Look for name of person and probate. Identify the place where the probate records are archived. In other words, if you determine that your family lived in whatever place in the United States, start finding out about how old or when were the earliest probate records, where are they kept, and usually they're going to end up in the county where your ancestor lived, or where he died, she died. Check the local laws before doing research. You just really need to know what the law was at the time if you're going to go through, because it may determine that there's a probate court in that state, meaning there's one place where they file all the probate actions. And so they may be filed in various counties, but all gathered together in one place. See? And it helps to contact the courts and find out what's available before you even start looking online or doing anything else. You might just call up the court, wherever it happens to be, and say, where are your probate records kept? So that might help you get started. The fact that they're not available through Family Search, Ancestry, Find My Past, MyHeritage, and all the other websites does not mean a whole lot, because these records are still, to some extent, sitting in the courthouses around the country. So here's the steps. Determine the date of death of the ancestor. That's the first step that you go through. You've got to have a date, because otherwise you're just, kind of shooting blindly, hoping you hit something. It's just not going to happen. Also, it's absolutely important to determine the exact place of death. Where did this person die? Because that may very well start triggering the whole process of a probate record. Investigate and determine which court or other entity handled probate matters at the time and place of the ancestor's death. This is just the next step. So you need to determine the court, level of the court, the name of the court. In some states now in the United States, it's called the probate court. Some places it's called the equity court. Some places it's called the orphans court. Some places it's called, depends. So you just have to go. There are lots of different names where the probate court is. Then determine where the surviving records are stored and whether the records are available online in digitized format. And this may involve a pretty extensive list online. I almost said the magic word too, expensive. Yes, it could be, because this is kind of something where you may end up standing in a courthouse someplace and asking to see the records. Search the court or other entity records both before and during a time period after the death. You may find probate actions filed years after the date of death. I've already gone through that. Just re-emphasizing that point, that you don't assume that, oh, I looked in the courts and probate at the time of death. I've had this discussion many times. And I said, well, how long after the death did you look? Well, am I supposed to look after the time of death? I thought the probate, no. Probate could have been filed years after the person died. You may have to keep looking for a long period of time to be reasonably sure that there's no probate action. So to find it, the court where the probate action may have been filed at the time of the deceased, adjoining counties, state archives, libraries, historical societies, and similar repositories, got an extra period in there, and check online. These are all places. In other words, you just have to keep looking. Cannot assume, for example, that the person, if they lived in Utah, for example, lived in Utah County, that they didn't have their estate probated in Washington County, because they had property in Washington County, and that's where they were from. And so that's where the estate was determined to have, the county the estate was determined to have jurisdiction. The court was the court where the state had, where the court had jurisdiction over the estate. Okay. You may have to travel to the location. Pretty obvious. It's especially if they're not digitized. And once again, they are not all digitized. They're still sitting on shelves. Always step back and make sure you're looking at the right place at the right time. This needs to be said every time you look at a new person. Make sure that the step is always right. Okay, thanks for watching.